Okay. Uh, Good afternoon, everyone. The Appellate Division is now in session, or I should say the Appellate Division 2.0 is in session. Welcome back. I know you've been up and down to Albany and to us a few times. This matter was last remitted by the Court of Appeals. The matter is JP Morgan Securities versus Vigilant Insurance et al. As I understand the batting order, we have three appellants that will be arguing today. Vigilant is the insurer represented by Mr. McGuire, and he has been allotted 5 minutes in wanting rebuttal. The excess insurers, Travelers Indemnity, I understand that Pro Havishi, Mr. Abernathy is going to be arguing, and Lloyd's and American Alternative are going to be arguing through Mr. Kirk, and they also going to be getting 5 minutes and wanting rebuttal. Did I get all of that right? Okay.
Yes, Your Honor.
Thank you. Ms. Eindick, I'm sorry, I hope I'm not.
Close, Indich.
Indish. So, Ms. Indish, I know that you're the New York attorney and you were going to be introducing Mr. Abernathy. Of course, he can appear pro havishi, so your application is granted.
Thank you very much, Your Honor.
Great. Thank you. So let's get going. Let's first hear from Mr. McGuire. You are muted, Judge. There you go.
Okay. I was saying thank you to you and all the other members of the panel, Justice Acosta. I'm going to address on behalf of the insurers, all the insurers, two issues common to everyone. First, the reasonableness of the settlement issue, and then hopefully I'll have time where Your Honor will let me have an extra minute to address the issue of the intentional harm. So with respect to the issue of the reasonableness of the settlements, the critical point is that as a matter of law, Bayer failed to meet its burden. It put on no evidence at all that the SEC would succeed on its claim that it had the authority to compel Bayer to disgorge not only its own gains, but its customer gains. None. And holding insurers to that burden is vitally important to the insurance market generally, because it operates as a check on insurers playing with insured's money, with the insurer's money. And that alone is a reason to reverse. But Bayer's failure is particularly important here because what's at issue is the reasonableness, primarily at issue is the reasonableness of Bayer's decision to settle and agree to pay $140 million in its customer gains. Now, two nationally prominent law firms, two nationally prominent lawyers representing Bayer submitted a Wells submission to the SEC, and they took the position unqualifiedly that there was no authority, the SEC had no authority to exact a dime of customer gain from them. 8 months later, Mr. Lyman, one of those attorneys, reiterated.
Counsel, let me interrupt for a second. What about the fact that there was actually rulings and civil actions against Bear Stearns that showed that there was substantial liability being imposed against it?
Your Honor, the issue is whether there was any showing, as they're required to do, that there was a reasonable probability. The fact that there may have been liability, I don't remember that argument even being.
But wouldn't that be evidence of liability? The fact that in a civil action against it, they were found liable? Wouldn't that be some evidence of liability?
Some evidence of liability, but the issue is reasonable probability of success on the claim for customer gains. That's the only issue. That wasn't an issue in the civil settlements, Your Honor. What the SEC's authority was. That's the critical question here. And Bayer put on no evidence, none at all. And as a matter of law, it can't be reasonable when they put on no evidence. What did Bayer do? It went to the position that it had zero possibility. SEC had zero possibility of succeeding on the claim, any claim for customer gain. Did it change its mind? We don't know. If it did, why? We don't know. Did it have what it thought were good reasons? We don't know, because there was no evidence from Bear, none. That's fatal. And in fact, asked at his deposition whether it was outside the scope of the SEC's authority to seek from Bear its customers' gains. Mr. Lyman was instructed not to testify, and he didn't. Not complaining, he was well within his rights to do that, to make that strategic call. But it's not a freebie. It comes with consequences, and it can come with consequences, as here, with respect to the burden of proof.
Mr. McGuire, what about the Bear paid substantially less than what was demanded of it? And I know that I mean, you argue that alone is not a basis for reasonableness finding. Can you go over that?
Yes, I can. I'd be going a little bit out of order to do it now, my own order, but I can address it now if you would prefer. I'm going to get to it in a second, but I'll do it now if you want.
I'll wait. I'm patient.
Okay. And I'm reminded there was no finding of civil liability in the civil action. The grant of summary judgment is all the more perplexing because Justice Ramos himself, in an earlier decision in this case, correctly said in denying a motion for summary judgment on the reasonableness of the settlement, said that it was, quote, a fact-laden inquiry ill-suited for summary judgment. Now, Bear's failure is even more glaring, and here's where I'm going to get to the point, Your Honor, that there's at the very least, a reasonable inference that Bear settled for more than 100 cents on the dollar of SEC's claim for customer gains. At a June 2nd settlement discussion, the SEC, oh, I'm sorry, let me back up a second, I missed something. With respect to its burden, in its submissions below, Bear repudiated its burden because it said it didn't matter whether the SEC had the authority. The fact that the SEC was asking was alone sufficient to justify the settlement. But back to the point. I'm sorry, I've gotten out of order. At a June 22nd, 21 settlement meeting, the SEC dropped its moonshot proposal. That's the one Your Honor is talking about, of a payment of $520 million of customer disgorgement and a $200 million penalty. That was 3 months after Bear criticized that methodology in its Wells submission. That's in the record at page 1983. It criticized it for 3 separate reasons, and it said, to our knowledge, it has not been accepted by any court. So during the June 21 call, an SEC staffer said that $300 million all in would be acceptable. That would be an acceptable number. There's no evidence, Justice Acosta, in direct response to your question, there's no evidence that the SEC was sticking in any way to its prior analysis called the Delta NAV analysis. To the contrary, the very next day, Bear presented its fair value analysis of customer gains, showing conservatively a customer gain amount of $140 million. And Bear, at that meeting, even reiterated its position that the gains achieved by its customers was not the appropriate basis for disgorgement. What happens? 2 days later, the SEC folds. It folds. And what do? They say it'll accept a settlement of $250 million with a disgorgement of customer gains figure of exactly what Bear proposed, $140 million. So they can stand here all they want and argue with no evidence that they had this great triumph because the SEC that they never had a triumph if the SEC was insisting on that. There's no evidence at all of that. How can that possibly be a reasonable a settlement as a matter of law, as the court below do? And I said that there's a reasonable inference here. The reasonable inferences go to the party opposing summary judgment. My clients, the insurers, didn't get that. Now, why would Bear do that? Why would it settle for 100 cents on the dollar. Actually more, because they said the $140 million was conservative. It was actually less, but they settled for $140 million anyway. Well, and that's because there's a misalignment of interests. Bayer had every incentive in the world to pay as little as possible out of the penalty pocket, because that's not indemnifiable, and they know it's not indemnifiable. But it has every incentive in the world to pay as much as to allocate as much of the what the money that the SEC is demanding to the disgorgement pocket, because then it can and it certainly contends that it can obtain indemnification. So they did have incentives to play with the insurer's money. And so for that reason, they failed in their burden as a matter of law. And for that reason, there should be a reversal. Summary judgment should be granted to the insurers, and at the very minimum, a bench trial. The arguments are basically the same with respect to the civil settlements. I don't want to take up the court's time with that. They're laid out in the brief. If I can, I'd like to turn briefly. Did you want to have a question?
Yeah, I'll give you a minute on the intentional harm.
Thank you, Your Honor. I didn't realize I was over. I couldn't see the red light, but I'll try to be very quickly. I think I can do it. In the Atlantic Cement case, which was cited by Bayer in its reply brief, that's particularly devastating to them. It establishes that our standard is correct, not the narrow standard that would make no sense, where you could only, where the public policy against intentional harm would have no application in the securities industry, because actors in the securities industry they act to get money, not to hurt people. In that case, it was a decision by Justice Alexander when he was on this court, and it was affirmed by the Court of Appeals. And importantly, it was affirmed for the reasons stated by Justice Alexander in this particular respect. And in that opinion, here's what the Court of Appeals eventually said through Justice Alexander. While it cannot be gainsaid that the insured intended to operate its cement plant, that does not mean that they thereby intended to cause damage to the property. Nor on this record can it be said that it was substantially certain that such damage would result from the operation of this plant. That's applying the standard that we contend for, that other cases stand for. So, and it just makes sense. How can the public policy of this state be that somebody can go around intentionally acting with knowledge that harm is substantially certain to occur, and then say, I don't have to pay. Insurers, I can pass it on to any. That is a perverse result. Now, it's all the more perverse because in this state, there's an important public interest in maintaining the integrity of the securities markets. I'll
leave it there, Mr. McGuire. Thank you. Let me first hear from Mr. Abernathy. You are muted.
Can you hear me now? I'm sorry.
Yeah, I can hear you.
Thank you, Your Honor. Sorry about that. David Abernathy for Travelers Indemnity. We briefed two issues: the demand for prejudgment interest from the excess insurers and the application of the profit or advantage exclusion. I'd like to start briefly by addressing the interest issue. The plaintiff is demanding not only the full limits of our policies, Travelers, and several other excess policies along with the primary, they're also demanding prejudgment interest against all those policies on a theory that all had an obligation to pay at the time the loss was incurred. And as to the excess, that's simply wrong. Our policies make very clear in unambiguous language that they have no obligation to pay until the underlying.
So your argument is your obligation becomes due only after the underlying insurer makes the actual payment.
Exactly, Your Honor. Until the underlying insurer pays, we don't have an obligation to pay, and prejudgment interest can't run on our contract obligation until it actually becomes due under our contract. The insured may pay loss, but the two Gulf policies that Travelers is responsible for pay loss because of exhaustion of underlying limits of specified policies, not because of payment of loss by the insured. And the condition in the policy also says that the exhaustion has to be accomplished by payments under the underlying policy. The insured can pay loss, but only the insurer can pay under its own policies. So this unambiguous language makes clear that we don't pay until the underlying insurers have paid. And this court and many other courts have held that substantially identical language requires that result. And in this court, JP Morgan Chase versus Indian Harbor, and the Forest Labs case versus Arch Insurance, and there are multiple other courts
You're only making that argument with respect to the excess insurers, right? You're not making that in behalf of, although JP Morgan seems to have made two arguments in your behalf, you're not making that prejudgment interest argument in their behalf, right?
Well, so the prejudgment interest argument is an argument for all of the excess insurers, right. But not the primary, but all the
not
excess.
the underlying insurer.
Right. Travelers has two Gulf policies. Most of the rest of the excess policies, including one that we're a party to, are using the federal insurance company form, and that is equally clear. In fact, the plaintiff has conceded that the federal language can only be read to say that the underlying insurer has to pay, and the insured can't exhaust the underlying policies and trigger those federal excess, including the one Travelers is on, with its own payments. I think it's important, Your Honor, to understand that this is not an arbitrary or technical or unfair result. This is a bargain for benefit to the excess insurers, and this is best explained, I think, in the TIAA Crest case that we cite in our brief. These provisions allow the excess insurers, when there's a coverage dispute with the primary and also sometimes with excess, it allows the excess to await the outcome of that dispute before it's obligated to pay. If not for these provisions, then the excess would either have to jump ahead of the primary and pay out of order, which is not consistent with the nature of excess, and maybe pay amounts that would be held not covered, or be exposed to interest obligation because the primary and the insureds continue to litigate. It's significant that the plaintiff cites Olin versus One Beacon, but that really proves our point, because in that case, the policy language allowed exhaustion by a payment by the insured, not just the underlying insurer. That's not the contract they negotiated for and made. Our contracts provide differently. If I can very briefly turn to the exclusion, the key point I'd like to make, Your Honor,
I'll give you 30 seconds on that, because you over your time, Mr.
Okay.
Arbor.
Thank you, Your Honor. The record is clear, and it's in the vigilant brief, that Bear Stearns engaged willfully in an unlawful trading scheme, and that the object of that scheme was acquiring profit and advantage both for Bear Stearns and for its customers. The exclusion says that when the claim arises out of the insured acquiring profit or advantage to which it's not entitled, the policy does not apply to the claim. That means there's no coverage for the claim, any part of the claim, including the $140 million that was customer gains. But critically here, there's no dispute at this point that $20 million of what they had to give up, profit they clearly weren't entitled to, was money that Bear Stearns got, not its customers. So clearly the SEC's claim was for disgorgement of that money as well as the customer gain. And because the claim was based on Bear acquiring that money and then having to give it back, the exclusion applies. Thank you, Your Honor.
Thank you, Mr. Arbor. Okay, Mr. Kirk.
Hi, good afternoon. Edward Kirk of Clydeco US LLP for underwriters at Lloyd's and AAIC. Underwriters and AAIC issued an excess policy to Bear Stearns that applies 50 million excess of 150 million, and that includes a prior knowledge exclusion that is not in the other policies. Specifically, the excess policy that my clients issued does not provide coverage where a claim is for alleged wrongful acts committed before March 21, 2000, or interrelated wrongful acts occurring after that date. And as of March 21, 2000, any officer of Bear Stearns knew of such alleged wrongful acts, which they could reasonably have foreseen could lead to a claim. So it's an objective and subjective and objective test under this exclusion. Now, under a fair and plain reading of the excess policy and the undisputable and overwhelming evidence in the record, the prior knowledge exclusion clearly precludes coverage for this matter, and we're entitled to summary judgment. At a minimum, any genuine issues of material fact should be resolved by a jury, and Judge Ramos should not have granted summary judgment in favor to Bear Stearns, dismissing our defense.
Counsel, are you arguing that there's a different standard for the National Union prior knowledge exclusion versus the prior knowledge exclusion in the other excess policies, or do all the arguments fall or win on the same basis?
We have our own prior knowledge exclusion, and I don't think it has anything to do with the exclusion that may or may not be in the National Union policy. Does that answer your question?
Why is the argument different for the National Union policy versus the other policies, which also have prior knowledge exclusion?
My understanding is, our policy has this exclusion. National Union, I understand, has taken the position that their policy also has a prior knowledge exclusion, but I'm not making that argument today. I'm just arguing on behalf of my clients with respect to this particular access policy. I hope that answers your question. So that's a different issue. I think they're arguing whether or not their policy actually incorporates this exclusion, but I'm not addressing that.
You're just saying that the prior knowledge exclusion should knock out the claim.
Correct. Yes. Yeah. With respect to the Lloyd's and AAIC policy.
And how are you interpreting the term officer in that exclusion?
Yeah. So the trial court basically accepted Bear Stearns' strained and illogical reading of the term any officer as used in the exclusion, and instead interpreted that to mean only the top 4 officers at Bear Stearns and possibly an employee who was allowed to purchase insurance.
But let me ask you, even if we were to reject the trial court's reading that it's only 4, wouldn't you agree that it has to be very high level executive or managerial officers, which is a limited group of officers?
I would not agree with that, because if you read the term is clear on its face, any officer. Bear Stearns is a sophisticated insured. It's one of the largest investment bank. It was one of the largest investment banks in the world.
Is your argument that it's unambiguous, the term officer? That
That's
there's
correct,
no
yes.
ambiguity in terms of what officer means or doesn't mean in this context?
That is correct. And even
why
if it was,
isn't it ambiguous? Since
because
obviously
there's
we're
only,
all having different interpretations of it.
yes, I understand. There is only one reasonable interpretation of it, and the interpretation or meaning that Bear Stearns has proffered is not reasonable. To say that the term any officer, and the word any is important here, means only the top 4 people, basically is rewriting the contract terms, and which is, absolutely frowned upon by New York law and basic principles of insurance. You have to read it in the context of the insured.
But if we accepted your interpretation, wouldn't that include an enormous amount of people at Bear Stearns, including people who don't really have top management responsibility? And it's clear that that's what it was intended to mean?
If you did, there would be a number of people at Bear Stearns who qualify as officers under their bylaws and their other internal documents, as well as testimony. So there is a substantial amount of extrinsic evidence showing that. But you don't even have to get there here, because the people at issue, the employees who were involved, participated in, had knowledge of the market timing and late trading scheme at Bear Stearns before March 21, 2000, were all senior management. And that's confirmed by the SEC order. In fact, the SEC had to prove that senior management knew and participated in this conduct in order to make a finding of a willful violation for aiding and abetting and for directly violating the securities laws. And I don't think that can be disputed. And if you look at the titles of the people we've laid out, we have a chart in our opening brief laying out in a lot of detail who the people were, what their involvement was, and what their titles are. These are senior people. In fact, 6 of these people who are heavily involved had significant supervisory and management function as heads of departments within Bear Stearns, including Mr. Del Vecchio, who ran the MFOD department, which Bear Stearns describes as a back office. But regardless, billions of dollars worth of market timing trades went through that office. In fact, all of the trades.
Counsel, you're conceding, therefore, that you'd have to use other, you would have to use extrinsic evidence or other documents in order to determine who exactly constituted senior management. Is that correct?
I'm not conceding that. I'm saying that it's on its face. It's clear. That's the only interpretation is officer, and Bear Stearns' understanding itself of who an officer was is clearly set forth in its bylaws. There's no argument that those bylaws were ambiguous and that these people did not have officer titles.
My confusion, therefore, is that if in fact you have to look to these other documents or other information, does that not mean that it is ambiguous or at least not clear on its face?
No, well, what I'm simply saying is if the trial court found, or if this court found that there was an ambiguity, then you would have to take the next step and look to the extrinsic evidence to determine whether or not you could determine the intent and understanding of the parties of the term officer by that extrinsic evidence. Judge Ramos failed to do that. He didn't look at any of that extrinsic evidence, and there's a lot of it. There are bylaws, there are internal documents, and there's testimony. And the SEC order where the SEC finds that senior management knew prior to that date. So our position is there is no ambiguity, but if there was, the court should have taken the additional step and looked at extrinsic evidence to determine the meaning of the term officer.
Thank you, Mr. Kirk.
Thank you.
Okay, let me hear from the respondent. So first, Mr. Ovis, you get 7 minutes. You are muted, Mr. Ovis.
Now we are. Thank you.
Okay.
Thank you, Your Honor. Let me begin with the reasonableness since Mr. McGuire did. I'm surprised it's even still being pressed. This was an arm's length settlement after the repudiation by all of the insurers of their obligations here. Under the Deutsche Bank case that this court decided, under circumstances like this, any reasonable settlement would be entitled to indemnification, and it would only be deemed unreasonable if there were no possibility that a worse outcome wouldn't occur after trial. Here, there was ample authority, including in the Second Circuit, that the SEC could in fact seek the type of remedy that it was seeking in this case. The demand it was making was hundreds of millions above what we settled for. Contrary to counsel's characterization of that demand as a moonshot, it was based on the Delta NAV method that the insurers themselves conceded in response to our statement of undisputed facts was an accepted method, and it was indeed the method that was preferred by the SEC and approved by many courts.
Yeah, I mean, I'm sorry. Can you spend a second going over the methodology? Because I know you argue that basically the risk of liability was substantial, but you know, Mr. McGuire seems to take issue with that. What are the factors that we should be considering in determining invalidating the methodology as a way of finding reasonableness?
Well, I preface it by saying that the more important point is whether the courts who was going to have to decide the case against us considered that a valid method, even if this court were to think otherwise. And we argued otherwise. But the Delta NAV method basically compares the price at 4 p.m. with the price the next day. We argued that a fairer method of evaluating the harm was to compare the price to the futures, the price estimated in the futures market, which we said precisely calibrated the value at the time the trades were actually processed. So it's a complicated matter, but that was our argument. The court, rather the SEC wasn't buying it, but it settled on that basis, even though there were a lot of cases out there upholding the Delta NAV method, and the insurers, as I say, stipulated that it too was a reasonable method.
Counsel, I'm going to interrupt and ask you to address another issue, because I know you have many issues that have already been addressed by opposing counsel, but the issue that I would like you to address specifically is the prejudgment interest in the excess insurers. What is wrong with their argument that the excess insurers, under the clear language of their policy, are not required to pay any amount until there's been a determination as to the liability of the primary insurer, and that in this case there is a good faith coverage dispute, which has been going on for years, obviously, as to whether or not there is liability under these policies.
Your Honor, applying a CPLR Section 5001, courts have repeatedly held that when an insurer disclaims coverage for an insurance loss, interest runs from the date of the disclaimer. In this case, of course, Bear Stearns was out of pocket,
But we're talking about
after the
excess
disclaimer.
insurance here. We're not talking
Yes.
about the primary insurance.
Yes, and these
Aren't there
cases,
clearly cases which hold that the excess insurer's obligation to pay does not come to fruition until a determination is made as to whether the primary insurance does or does not provide coverage?
In
No,
fact,
no, you're right.
if I can supplement that, I mean, TIA CREF talks about the actual payment having been made by the insurers. That's when the excess insurer's obligation is triggered. So if you can address.
multiple points here. First of all, in cases like Varda and Granite Ridge and Domodor, the courts say when an insurer disclaims coverage, any alleged condition precedent requiring the insurer to perform something like going and collecting from the from the underlying insurers is not effective, and insurance runs or interest runs from the date of the disclaimer. I note also that the National Union policy in this case specifically says that payment can be made by the insured, not only by the underlying insurers. And the Travelers policy says it can be discharged by all payments, doesn't specify whether it's the insured or the insurer. And only the federal policy it specifies that the insurer is the only party that can pay the underlying limits. So clearly underlying limits can be paid, as in the National Union case, by the insured. But in any case, CPLR 5001 cuts through that. It's not a question of fault. It's not a question of whether the disclaimer was correct or not. And clearly, Court of Appeals has now established this past November that it was not correct. Once a party is enabled to retain funds that otherwise would rightly have been paid over to the plaintiff, but for a breach of performance of contract, interest runs. Here,
But don't you have to look at the contract itself and what the contract says about when payment becomes due? And don't these policies say that under the contract, the payment becomes due when it's excess, when the primary has been paid and was exhausted?
Well, as I said, most of the contracts don't actually say that, but the answer is no. Under CPLR 5001 and the cases that apply it, where there is a disclaimer, interest runs regardless of fault from when the payment should have been made, but for a breach of contract. What the insurers are saying here, they concede that if any one of them had breached, that one would be liable for prejudgment interest. But because all of them breached concurrently, none of them can. They're all hiding behind vigilance brief. The problem is that 5001 says exactly the opposite. Even if it were only vigilance breach of performance of a contract, it would trigger the obligation on the part of all of them to pay prejudgment interest on monies that they were able to retain because of that breach that otherwise would have been paid over. So that is why these cases that I've cited, Varda and Granite Ridge and the like, specifically hold that regardless of what condition precedent might be stated for the timing of payment, prejudgment interest, which is not the same thing as when you decide to actually make the payment, prejudgment interest runs from when the payment should have been made, but for a breach of contract otherwise. If I could just briefly, I know we're very short of time, Mr. McGuire has conceded that no one at Bear Stearns intended to inflict harm. He hasn't mentioned Goldfarb. In Goldfarb, the Court of Appeals specifically said that other than solely punitive remedies, which the Court of Appeals has now said are not our remedies, this very narrow exception to the enforcement of contracts as written only applies where there is a subjective intent to inflict harm, where there is a purpose of inflicting harm, which everyone agrees doesn't exist here. Goldfarb goes so far to make the point and say, even where the conduct is not merely reckless but wanton, that is, in conscious disregard of the rights of others or utterly without regard to the likely harm to others, it is insurable as long as the insured did not specifically intend to inflict harm and make the same point in Slaco. Justice Gorsuch, in another context in the Manitow case, says the same thing. Intent to harm is different than doing something that will cause harm to ensue. So we think there's nothing left of their substantive arguments against liability, and the cases and Section 5001 require that payment be made. So for all of the reasons in our brief, we think the judgment below should be affirmed in its entirety.
Thanks, Mr. Ovid. Let's hear for 3 minutes from Mr. Schaffler.
Yes, thank you, Your Honor. So the prior knowledge exclusion turns on the definition, at least in significant part. The threshold question is who is an officer, and the contention by underwriters that it's not ambiguous is really an untenable suggestion. The Second Circuit in the Alenikoff case said it's ambiguous. Everybody can see on the face of it that it's ambiguous. It could mean anything from the top managerial people to nearly 4,000 people in an organization of 10,000 people, 40% of the workforce, which is clearly an unreasonable position. And it's an exclusion. An exclusion has to be in favor of coverage. And it's an exclusion that is designed to prevent someone from buying insurance because of the knowledge of a prospective claim that they know might happen because something that occurred. That does not have anything to do with whether somebody who has a title in a financial services organization, which thousands of people have, a vice president or associate director, it knows something or doesn't know something. It has to do with people who chart the course of the organization in terms of financial and risk management considerations. So it has to be a small number of people, or at least a limited category of people who are in that kind of position. Now, nobody's saying it has to be 4 people. We put in the Edlow affidavit, who is the corporate secretary, who identified different functions. And that's a significant cross-section of the senior management of the firm. But even if you went down to senior managing director, of which there were 456 at the time in January of 2000, there's no evidence in this record at all that anybody who was a senior managing director knew of late trading. There's no even allegation of that. They're talking about somebody who was basically an elevated kind of clerk. This guy named File and his superior, who was in charge of a very small group of investors named Harant, who was a managing director. They talk about Jim Delvecchio, who, because he has a title of associate director, and they call him the head of the department was basically a back office function. It would be like saying somebody who is in charge of the word processing department, which does significant that the firm couldn't function without it. But that doesn't make that person one of the leaders of the organization. So it's really ridiculous to say that, and it's an exclusion. They talk a lot about extrinsic evidence. There's absolutely no extrinsic evidence of what the term officer was supposed to mean in this insurance policy. It was not a negotiated term. It's their exclusion. If they want to say—
You agree. I mean, Baer makes a lot out of the fact that officer is not defined in the policies.
Absolutely. Officer is not defined in policy. And if insurance company wants to put in an exclusion and they want to make it applicable to 40% of the workforce, they should say something about that. They should define it. That's their job. They're the ones who wrote this, not us. They rely on the SEC order and statements that they're talking about senior managing directors or senior people. I mean, these are the SEC's allegations in a document that's basically their complaint, which of course they'd have to say that, but they don't identify anybody in particular who is within the categories that we're talking about, who we're talking about 3 years before any claim was made here. And I also specifically want to mention, as to market timing, there's nobody who knew about late trading, absolutely not. As to market timing, this is a situation, they talk about thousands of complaints. Market timing was something that was actually well known. There were many companies that liked it. There were some companies that hated it. They were writing letters saying you should stop doing it. We're asking for your help to stop doing it. Bear Stearns tried to do that. There's no evidence that anybody at a senior level in Bear Stearns knew that people were deceiving mutual funds. And there never was a claim by any of these mutual funds. It wasn't until 3 years later there was any claim by a regulator. It was not illegal. It was not regulated by the SEC. In fact, they specifically decided not to regulate. Talk about 2020 hindsight. I mean, this is something that has no possible inference that you would know as of this time of a claim that could give rise to a lawsuit.
Thank you, Mr. Schaffner. Okay, let me hear rebuttal. Mr. McGuire.
Thank you, Your Honor. Can you hear me? Court hear me?
I can.
Okay, thank you. We did not stipulate that the delta NAV method was an acceptable method. Quite to the contrary. Please look at the record citations. You'll see that we do not. Who disputed it? Bear disputed it. Let me read from your Wells submission. Here's what it says. To our knowledge, this is 1983, page 1983, footnote 57, quote, to our knowledge, it has not been accepted by any court and should be not embraced here. And then 3 reasons why it shouldn't be. And that position was, there's no evidence that they ever went the other way on that. They cited cases. They said there's ample authority supporting disgorgement of third-party customer gains. They cited on that same page authority that they had no authority to disgorge third-party gains. Finally, they come up with a case, Mr. Pitt, years after a case decided in 2014, Contarini's, irrelevant. It's an insider trading case. Rules are completely different there. Contarini's was also questioned by the United States Supreme Court. This position that these 2 prominent law firms took, that there was no authority to do it, was well taken. They never backed away from it. There's nothing in the record that says that they backed away from it. And we argued that the same thing, that there was no authority to disgorge third-party gains. The case my adversary talks about, the Deutsche Bank case, that was a decision by Justice Friedman. He actually wrote 2 of them in that case. They do not support that proposition at all. I just want to return to one thing with the intentional harm. This court's decision by Justice Mazzarelli for a unanimous court, you were on the panel, Justice Acosta. It's the law of the case. When findings of the SEC are being put forward to support a public policy exclusion, it blows through contract language that would otherwise keep it out. Thank you very much.
Thank you, Mr. McGuire. Mr. Argonath?
Yes, can you hear me, Your Honor?
I can.
Oh, I got luckier this time. Thank you. I hope the court will carefully examine 5001 CPLR and the cases, because respectfully, when Mr. Obis said that the excess insurer's denial of coverage triggered prejudgment interest, that's just wrong. That's not the law of New York. In fact, we cited multiple cases that say an anticipatory repudiation under a contract does not start the running of the interest. Why? Interest is not a penalty for breach. It's compensation for loss of use of your money after you're supposed to have it under the terms of the contract. So until the terms of the contract say you actually should have it, prejudgment interest can't run. And these contracts say you can't have it until there's exhaustion. Granite Ridge and Varda are not controlling. They're not even relevant here. Granite Ridge isn't even an exhaustion case. It's a proof of loss condition. You might not require a proof of loss from an insured after the excess insurer says it's not going to provide coverage, but saying we don't think the loss is covered is not a waiver of the exhaustion requirement. Yeah. Look at the New York cases and put the language of our policies next to the language from Indian Harbor, Arch Insurance, Forest Labs. You'll see that all those policies say the exhaustion has to be payments under the underlying policies and only the underlying insurance.
What about the 2? So it's not upon disclaimer. I mean, they cite 2 cases for that proposition, the Florida case and another case. What's your answer to that? Are they inapplicable or inopposite?
Again, I would say that the controlling cases, the New York decisions, are clear in saying that if the policy says exhaustion has to be through payments under the underlying policies, that means clearly and unambiguously it has to be the underlying insurers, not the insured that pays. And that means Bear is wrong when it says we can pay the loss and therefore accelerate the excess
So
obligation
actual
to pay.
payment, not disclaimer.
Actual payment. And the disclaimer, we said at the outset, Gulf said, we don't think this is covered, but if the ultimate determination is that it is covered, we will pay it, but not until the required exhaustion is done. We didn't waive exhaustion, and by expressing a view that it wasn't covered, that's not a waiver of the exhaustion requirement of the policy.
Okay, thank you.
Thank you, Your Honor.
Okay, last, Mr. Kirk.
Yes, so quickly, Mr. Schaffler, he argues that nobody in a senior position knew anything about late trading or market timing during the relevant period. Well, that's not what the SEC found, as detailed in the SEC order and the corroborating information that we put into the record. And also why it's not why Bear Stearns paid $250 million to settle for these violations, willful violations of the securities laws, which required a finding of scienter by the corporate entity, which in fact required that they show that senior management knew of and had knowledge and intent with respect to this behavior. The term officer, based on Bear Stearns' own understanding of who they were, is clearly laid out in its internal documents. It's not different than what our position is. Their current position is not reasonable. It's not a reasonable reading of the term, but you don't even have to go there if you're uncomfortable saying that 40% of the company would constitute officers and therefore would be too broad, because here clearly the people at issue with knowledge and who participated in the late trading market timing scheme were in a position where they had significant supervisory and management powers, including senior managing directors, which Mr. Schaffler seems to concede that at least they were officers. And if you look at our briefs and the record, you'll see that a number of these senior managing directors had significant knowledge and, in fact, participated in some of this conduct prior to the cutoff date of March 21, 2000, including significantly knowledge of thousands of complaints and stop orders from mutual funds who begged Bear Stearns to stop their customers from market timing in their funds. Instead of doing so, and after reassuring the mutual funds that they would do that, Bear Stearns, in fact, went ahead and used deceptive devices in order to disguise the identity of their customers, including the use of multiple account numbers and multiple RR numbers. Thank you.
Thank you, Mr. Kirk. Okay, thank you, everyone. This session.
Thank you, Your Honor.
Thank you, Your Honor.
Is now closed.
Thank you, Your Honor.
Thank you all.